Lastly, we should be aware of executive orders. And as I said earlier on, executive orders come from the executive branch. The president gets to make an executive order that affects federal employees and anybody doing business with the federal government. And so the one that's most prevalent is the EEO Executive Order 11246, passed in 1965 by Lyndon Johnson, called Affirmative Action. And it required organizations that have 50 or more employees and a $50,000 contract with the government to affirmatively attract qualified women and minorities to their organization for hiring purposes. It does not order you to hire people who are unqualified just to fit that quota. And that's where that quota versus affirmative action thing becomes a challenge. Affirmative action simply says we need to do our best to make sure we are attracting the most qualified women and minorities to our company, that we are proactively, affirmatively reaching out to these groups and saying, come apply. And we need to be doing the same for the majority groups, right? This is not about, well, we'll only do it for minorities and not for majorities. We have to proactively go out after all groups to attract them to come to the company. But specifically, this law focuses on how are we making sure that underrepresented employees are also being affirmatively approached to make sure that they can, find a job opportunity, or at least apply for a job opportunity in the company. Your standard that you're held to is a good faith effort, which means you have to make a good faith effort to reach these people through recruitment. You have to make a good faith effort to ensure that the people in your company are prepared and all have the same opportunity for advancement, and that they have access to training and development opportunities, same as everybody. So affirmative action is about making sure that you have a workforce that is ready, and that you are proactively doing something to make sure that your workforce is ready. So while primarily recruitment is one of the major things that we do with affirmative action, training and development can also be a part of an affirmative action plan as well. So aside from the required 50 employees or $50,000 contract, you can also be ordered by the courts to do affirmative action, and that comes when you have a long history of discrimination and underrepresentation of certain groups in your company. So the courts might order you to proactively go out and do affirmative action. So in those circumstances, the court orders you to do affirmative action. You've got a bona fide seniority system. Which holds true? Is it the court order to do affirmative action or the bona fide seniority system? And we'll go back to the basics. The bona fide seniority system wins, even over the court order for affirmative action, because the bona fide seniority system is the rules by which we make decisions for hiring, and it has to be a legitimate system. It can't be a surprise. Oh, hey, guess what? We're going to do a seniority-based layoff now. It has to be a legitimate system in your company where you say, we always make our hiring decisions and our firing decisions based on seniority. And where everything is, the merits and the rewards that we get are based on seniority. When you have that legitimate system, even though the courts are ordering you to do affirmative action, they're not ordering you to do affirmative action when you're laying people off or firing them. They're ordering you to do affirmative action when you're attracting people to the company. So it's not really anti-affirmative action to have to lay off the last people hired and keep the most senior people. Even though it may not feel fair, it is fair given the the court order. Lastly, people can just voluntarily comply to do it. They don't have to, but they want to because they feel like it's the right thing to do. So again, that's important to note and to keep in mind. Other executive orders, and I only include these as an illustration of how, even though we don't have federal laws that protect people based on sexual orientation, Bill Clinton in '98 and then 2000 passed these two executive orders, making sure that employment opportunities and training opportunities didn't discriminate against people who had a minority sexual orientation, such as that they were gay or lesbian or bisexual. And again, just because we don't have federal laws that make protections at that level doesn't mean that we don't have executive orders and the ability to say we're not going to discriminate in employment at the federal level based on these issues. So the hope is that eventually that will spread out to laws across the nation. But right now it's only limited to federal employees and any state or municipalities that have rules around that. So this slide is a nice summary of how the legal process proceeds. If we have a charge of discrimination, I have to determine whether it's disparate treatment or disparate impact or adverse impact, as I call it. If it's disparate treatment, then I have to say, meet my prima facie case, make my charge. My attorney brings it to the defendant has to say there's a non-discriminatory reason for why I didn't hire this person. They have to be able to show it. And the plaintiff can say, well, that's just a pretext. They would have to demonstrate that, but that's what gets demonstrated in the court of law, whether or not that was just a pretext for the discrimination, or whether they actually legitimately, had a legitimate reason for not discriminating. Alternatively, on disparate impact or adverse impact, you make your prima facie case, you go back to the employer. The employer has to show you that it is a job-related practice, or it's a business necessity practice, or it may, for example, be a bona fide seniority system. So even though we're laying off more women and minorities because they're the last ones hired, the bona fide seniority system still trumps that diverse hiring. So I have to demonstrate that the practice that I'm using is job-related, business necessity, or part of a bona fide seniority system. And so when I can do that, then, the rebuttal from, is, you can tell me that it's one of those categories, then I'm fine, right? Or if I may choose to say, that the practice is not job-related, in which case then the employer has to prove that it's a job-related, that it's been validated and it makes sense, like in the firefighter circumstance, or like in the high school diploma circumstance. It wasn't valid, right? Or you can say that there are other tools that the company could use that would have less of an adverse impact, and the company refuses to use them, which is why, again, it's in your best interest to make sure you have a selection system that's balanced between perhaps a tool that has an adverse impact, but counterbalanced with tools that do not have adverse impact, and that's one of the ways that you can manage that. So the plaintiff has, can come back and say, well, it's not job-related, or there are better tools out there that don't have adverse impact. Why aren't you using them? In which case, then that's sort of how it has to be responded in the court of law. An agreement is made in terms of whether or not the plaintiff's response is actually legit. So again, that you can see how that sort of flows through in that way, and eventually you decide whether or not discrimination actually did occur, illegal discrimination actually occurred. That's really where it comes to with the courts. The OFCCP is the organization that monitors affirmative action and any sort of federal contract compliance. So affirmative action plans are all written and developed and then filed with the OFCCP to ensure that they are following contract guidelines. It's basically, they're the oversight body that says, we want to make sure that, we're following all the rules in terms of the contracts. The EEOC handles the employment law stuff, the things that are not around affirmative action but are about Title VII or the ADA or the ADEA. And the EEOC, the way that it basically works is the EEOC looks at a particular case, decides whether or not it's legit, whether it fits the criteria for a case, and they can either decide to take the case on and actually sue on behalf of somebody, or they can decide that, we're not going to take the case on, but you have a case, and here's the certification, and go to town, give it to an attorney, and an attorney will take the case on. The EEOC these days only takes cases that are high-profile cases or are at the cutting edge of a new way of thinking about the interpretations of employment law around, and nowadays it's around gender identity and sexual orientation covered under Title VII. It used to be same-sex harassment, where men harassing men, not around homosexuality, but because they don't fit gender norms. So, or women harassing women because they don't fit gender norms. And so same-sex harassment, again, was one of those high-profile cases. Another high-profile case was, a male accusing his female boss of sexual harassment. It's a rare circumstance, but it still occurs. So in those circumstances, the EEOC takes on those cases. But when it's regarding affirmative action and affirmative action plans, this is all managed by the Office of Federal Contract Compliance Programs, the OFCCP. And the enforcement basically means that they can do audits and reviews of all your plans. They can monitor them, make sure that you're following suit. You've got to show every year that you're making your good faith effort in order to be able to make those plans go through. And so you're constantly being monitored to make sure you're living up to what you promised you would do. When the employer is not found in compliance, they're first of all encouraged to get into compliance, and if they continue to refuse that, then they might be ordered, court ordered, penalized, and then court ordered to engage in affirmative action, or they might lose their contract, their status to do the contract. So they might have to pay a penalty, or they might have to lose their contract, or they might be court ordered to continue to do something. So the difference between the EEOC and the OFCCP is the EEOC sort of acts on your behalf kind of like as an attorney, whereas the OFCCP is an oversight body that can actually penalize and punish you. The EEOC cannot penalize and punish you. It can only take you to court. OFCCP doesn't have to take you to court to be able to review and punish you if they feel it is appropriate. The best EEO and AA affirmative action practices have the following criteria. They have to comply with the law. You know, any affirmative action plan that says you have to make hires that are not qualified it violates the law, violates the policy, the regulation. It promotes equal opportunity and addresses all sorts of barriers that adversely affect equal opportunity. So it gets at, well, why are there differences in hiring rates? Why are there problems in people not having the qualifications that they need? So good EEOAA practices are sort of getting at where are those barriers and how can we remove those barriers. EEOAA also requires to have really strong management commitment and accountability to get things done. And it requires really good communication amongst everybody and some transparency. Further, you want something that has reasonable results, that there's some noteworthy results out there. You know, it's not enough to say, yeah, we have a practice, but it doesn't change the way that we do things. We want to see that there's some changes. And lastly, we want to make sure when we make changes that it's not considered unfair by anybody, including white males. I mean, there is an extent to which people are going to feel like, well, I have less opportunity now. Well, yeah, but it doesn't mean you're treated any differently. You're treated in the same way in that everybody's held to the same standard, the standards are considered fair, and the best person has to compete. If you don't get the job, it means you didn't compete well, you weren't able to do the job. It is a problem if we're only hiring people because they fit into those categories, their race, their sex, their religion, etc. We want to make sure that we're not treating people unfairly because of those reasons. There are a few other laws that fall under the guise of equal employment or staffing issues, and one of them is around the Immigration Reform and Control Act of 1986, which means that we can only hire people who we know verifiably have citizenship status, and we can verify their citizenships obviously through a passport and various other documentation, and they could be natural-born citizen or one that obviously passes a test and becomes a citizen over time. And also we can only hire people who have certain visas. They have to prove they have the right to work here in the United States. Not everybody gets visas. That becomes a big challenge. So the I-9 started to make it a little bit more challenging for anybody to have jobs, and it sort of tried to clamp down on unauthorized aliens doing jobs. Now, again, the argument, nowadays about illegal aliens, it's not like these people are coming in and stealing CEOs' jobs or higher-level executive jobs. Whereas before the Immigration Reform Act, we saw people coming in and taking over, different kinds of jobs when they weren't legally allowed to work in this country. So this act really sort of started to put the onus on the employer to verify that people were legitimate and able to work. And it didn't authorize them to investigate whether or not the passport somebody showed them was legitimate or the Social Security card they showed them was legitimate. So, employers still have to take on face value that the documentation that's being shown to them is legitimate and it actually proves their citizenship. So, if you cannot prove that you're a citizen or that you're eligible to work here in the United States legally, you're not supposed to get the job. And if a company violates that, they may get penalized for every employee that they have that doesn't meet the criteria to legally work here in the country. And this has become more strict now after 9/11 with the Homeland Security Act and things like that. So it's become even more difficult for aliens to come and work in this country. The next law is the Polygraph Protection Act, which basically prevents employers from using the polygraph as a selection tool. Can it be used as an investigative tool? Absolutely. It still can't be used in a court of law, but the polygraph can be used as a tool in an investigation, and particularly if we think someone may have embezzled money or things like that, we can use the polygraph to help us with some investigation. But we know it's a flawed tool. We know it's not perfect in its ability to definitively predict. All it can predict is that someone is agitated in being asked those questions, which then leads us to investigate something further. So the goal here is we cannot compel somebody to take a polygraph. We can't discharge them or discipline them or fire them or what have you for not taking a polygraph test. We can't use the polygraph in employment decisions. We can use them in limited circumstances when we're doing investigations to see if there's things like embezzlement and stuff like that. And again, if it finds that you've been using it and you've been using it pretty extensively for hiring purposes, you can be fined for that. The last major staffing law of note is the Fair Credit Reporting Act, which basically says if we're going to use a credit report in the hiring process, for example, if we want to make sure if we're going to have someone working for the SEC or working for a bank or working with money, and we want to do a credit report to make sure they don't have debts or have a bad credit, which makes them an embezzlement risk. If we are using the report and we're clearing them and we're making a hiring decision based on that, they get the same rights as anybody else to get access to that credit report and to have the opportunity to fix it if there is a problem on the credit report. So if there's an adverse action that occurs because there seems to be a negative report coming through, the person has the right to know that, the person has the right then to access the report and to make fixes to that report. And that's all part of the FTC. Federal Trade Commission monitors that, makes sure that if we're going to use those credit reports, that we're using them fairly for people. And again, if we use it inappropriately and we're not giving people an opportunity to know why they got their job was rejected because of that credit report rating, then we are going to get fined for that. So if you're supposed to give a credit report and you don't get the job and they don't tell you anything about what happened with your credit, you have the right to sue, for that. As I said before, state and local laws are going to be very different than federal laws. They are patterned after federal laws. They are usually, the federal law is the basement, and then the state and local laws are built off of that. So at a minimum, the federal laws sort of set the tone for what can be expected, but state and local laws can be stricter than that. Where do we see differences in state laws? We see state laws differ from place to place based on torts. Every state has different tort law. Employment at will varies from state to state. We also see differences in workers' compensation and things like that, in unemployment insurance and what the rules are around unemployment state to state. So there are some state laws that guide many of the decisions that we need to make in hiring, but at a minimum, they have to meet a minimum threshold of what the federal government sets in terms of particular laws. For example, around the marriage equality, right? Even though it's not an employment law, the federal government said, we can't discriminate based on that, so all the states have to follow suit and they have to allow, marriage among same-sex marriage. Other things that are covered under state laws that are going to vary from place to place is polygraphs and honesty testings and personnel records and AIDS testing and stuff like that. So it's important to know what your state and local laws are and how they differ from the federal government on those sort of aspects.